And this question comes from Annie, who is a concerned neighbor. Now, Annie lives in a complex. Annie says that one of the neighbors in the complex, the owner of a particular unit, let out his property and then just continue to manage the lease on that particular property. She says, and she recounts the story, that the tenant here stopped paying rent. And because of the tenant stopped paying rent, the owner arrived and then broke down the door, and the tenant then replaced this door with a door that is less aesthetically pleasing for the estate itself. Now, the reason I raised this is because already there's an eyesore around the fact that there's certain things that are happening on the property itself and to the face of the property that aren't in line necessarily with the complex's regulations and rules and general aesthetic. She says now that these now are illegal occupants of the property because they've stopped paying rent. And she says that they're quite troublesome. They cause a lot of trouble, and they believe, the tenants of the complex believe, that these occupants are, the cause of a spate of criminality within the complex itself. She says that all attempts by the body corporate and the neighbors to contact the owner now have proven unsuccessful. They've gone as far as enlisting the services of tracing agents, and still no response from the owner whatsoever. Annie now says that she's had issues with regards to the fact that they are not sure, as a body corporate and as and neighbors, on what to do here, because they cannot proceed with an eviction because they're not the legal owners of this particular property. She says it is becoming an issue, and in the face of not being able to contact the owner, the body corporate and the neighbors are uncertain about what route to follow from a legal perspective, and I think that's important, from a legal perspective. So, Salma, what kind of advice can you give Annie as a neighbor, concerned neighbor, and to the body corporate as well, who's faced with this particular situation?
Well, Chris, the good news is it sounds extremely complex, but there's actually a relatively simple answer. Problem with simple answer in law means probably going to court. So it's not the cheapest answer that I have, but there's actually quite a big amount of opportunities and possibilities of how to address the issue. First of all, we have CSOS, the Community Schemes Ombud Services. You do not have to be the owner. The thing is, the Community Schemes Ombud Services and the Community Schemes Management Act both creates a situation where there is now, in fact, a relationship between the body corporate and the tenant of the property. Insofar as we even need to provide the information of all the occupants in the unit to CSOS, so CSOS knows exactly who is occupied. Now, how many body corporates comply with that, I can't tell you. I don't hang out at CSOS ever, but there is a relationship between the body corporate and the tenant, which there wasn't prior to the promulgation of these pieces of legislation. So under the Sectional Title Act, there wasn't, but under the Sectional Title Schemes Management Act, there is, in fact. So they can go to CSOS, even though they do not have the owner, and they can't contact the owner. But very importantly, they do have the ability to litigate against the owner. The fact that he's not paying his levies means that they can approach the court. And you don't need to only approach the court there for payment of the arrears. They have options. Because they're not paying the levies, if utilities are included in that, they do have the right, and that's a very quick, easy, cheapish application to do. Approach the court for utility disconnection order and say, okay, let's mitigate our damages. Court, and guys, please listen to what I'm saying, court, not go there and disconnect electricity, get a court order to do that, and it can be done. It's a relatively quick and easy application to do, not a very expensive thing. We disconnect the utility supply on court order, we interdict them from reconnecting, and while we're anyway in front of the court, we might as well get the court to give an order to the owner to attend to enforce the lease agreement, because that's going to be part of the typical conduct rules in a body corporate, that if you are not occupying the property, but you are renting it out, that you will ensure that the occupants are complying with the conduct rules. So It's an interdict that you can get to compel them to do that. However, the fact that there's arrears also mean that we can obtain a court order. And remember, in terms of the Sectional Title Schemes Management Act, your unit will serve as the domicile address. So you don't need to really have this guy. You can approach the court and you can say, this is my domicile address, but I need to caution the body corporate here. The court's going to frown on that. The court doesn't like to declare property specially executable if we can't show that we've done everything in our power to try and inform the owner of this. But that's an easy thing to get around. You approach the court for an alternative service method. So you go to court and you say, listen, court, this is the only domicile address I have. However, we know the owner is not going to know about this. So allow me to serve via Facebook, via Instagram, via WhatsApp, via whatever. But you can get a court order for that. Also not the most expensive thing. And while you're anyway in front of court to do the utility disconnection, where you're going to serve on the occupant's going to be aware of this. You're just already going to rattle the cage. So there's a lot of things that can be done. Yes, the body corporate does not have the right to do an eviction on behalf of an owner, but very much so if the owner is not paying his levies and we get to a point where we obtain a judgment against the owner for his arrear levies, we've done the utility disconnection application. We've done the application to declare the property executable because we cannot execute on that judgment in any other way than that. Then you can approach the court, do an alternative service application, make sure that it comes to the owner's attention, and sell the property. And once the property is then sold in execution, luckily the purchaser of that property will then be responsible to do the eviction, but at the same time will then have the locus standi to attend to that eviction. So Annie, I hope I at least gave you that where you can clearly see there's a lot of options. So get into contact with either Bruno or myself, and we would happily guide you through the process. There's a lot of self-dismeer. What's my English word I'm looking for? But there's a lot we can do.
Thank you, Salma. Really appreciate that. And I think Annie does as well. And so would the neighbors of this particular unit.